1, 2, 3.
Hello everyone, this is Adil Farooq and I brought this legal launch with Adil Farooq, and I will be here to address to my audience, and I will be responding to their questions. If you have any questions, you are most welcome. You can ask me your questions and I can try to respond to you online, or I can send you a message to see if you can have our answer from me. Otherwise, you can book a live session with me or book an appointment with me, and we can take it from there. Just for introduction purposes, my name is Adil Farooq, and I am a lawyer in Mississauga. I'm in this profession for last almost 25 years, and I know my job. As I mentioned, that I'm here for the last 25 years, so I will be available to give your answers if you have any question. This is my very first live session, and I try to advertise as much as I can, but I know we guys are busy. It's Tuesday noon, and I selected this time because I believe that maybe few of you maybe in at your lunch break and will have some time to come online and get advantage of this live session. So to start with, I will just tell you that what what are the plans and how we will take this session for the next maybe 20 to 30 minutes. In this session, I will go through, I will select a topic of my own choice, and I will go through the different angles of that topic. But if you have any other topic in your mind which you think that you need some input or you need some information, you are free to send me a message, and in the next program I will try to have some information about that specific program. So to start with, today I selected the very important topic about the wills and power of attorney, which is very important, especially when we are in we have some assets in Canada, or when we have some responsibilities in the shape of our minor children, and we want that after our death our assets should be divided according to our will. And if you don't have the will, you are thinking about that, believe me, your assets will not be divided until or unless you will have a proper document which is called will, and that should be, actually that's I always advise, should be done by a qualified lawyer. If you will try to do it at home, which I know few of us try to download from some website or use the technology by an AI, and try to draft something and sign it and put it in our system. This is not very wise. This is not very wise that if you will do that, because if you will do that and that document was not properly drafted and or executed, you are creating a problem for your loved ones after your death, which you don't want. And I know you may save a couple of $100 by drafting something from your own resources, by doing some research on Google, or asking some AI software to draft it, or pay some nominal amount to draft it. But that may be not a legally binding document in the eyes of the court when we will file this document in front of a judge after your death. So I don't suggest that you should do that. If you do that, you, as I mentioned, you may save some couple of dollars, couple of $100, but your children or your beneficiaries and your trustees may end up spending way more than what you saved by not doing that. So for us, it's a very straightforward process, but I know most of you don't know about that process, so I will guide you through about this process. Whenever you think about the making of a will, always talk to a qualified lawyer or someone professional who has knowledge about this process. When somebody contacted us, we told them about that we will set up two meetings. First meeting may be done by phone call or by Zoom or by WhatsApp, whatever way you guys want, just for your convenience. And at that meeting, we will go through with all the aspects of the will, and we will take all of your questions and answer your questions so that you will have knowledge that what you are doing. So during that meeting, we'll explain you the advantages and disadvantages of the way you decided to divide your assets. Once you will finalize all of your information, we will draft a will and we will send it to you by email and give you the time to review it at home, talk to your wife or husband, and discuss if you guys realize that you guys missed something while giving me the instructions, or you realize that I make some typos or some error in the drafting the will. You can always come back and inform us, okay, this is what you thought and this is what is missing, or this is what you want us to update. We update that document, and then the second meeting is always in our office. You have to come in person in our office, and with your original IDs, of course, and we will have two witnesses, which is the requirement of to draft a document. So once we draft the document, you will attend our office, and in the presence of the witness, we will execute that document. There, I can give you a couple of hints which you should think about before you have the first meeting. First of all, if you and your spouses are making this will together, discuss with each other that who will be the trustee of your will. Yes, maybe one of both of you will be the first trustee of your wills, but you need an alternative trustee. So your alternative trustee should be someone who is sound minded and 18 years of age. So talk about this between both of you before you come to me, because I will need that name. And after that, you also need to see or think about that how you want to divide your assets. And that is also very important for you, because division of assets is one of the things which which why you are attending to a lawyer's office to make a will. So you can discuss that if wife will pass away, who will get her assets, and if the husband will pass away, who will get his assets, and once both of you pass away, who will be the beneficiary of the family assets. So even if you have some discussions during the meeting, I will explain you the advantages and disadvantages of the division, whatever division you want. That's a first part. And the second part, if you have minor children, you should be giving a special attention to this part, because you want to name someone as a guardian of your children. And we will ask you this thing as well, that who will be the guardian of your children if both of you passed away. So these are the basic things which I will ask you once you will be in the meeting, and once I have you may have many other questions, and of course every person has his own circumstances, every person has his own on details of assets, which we, of course, that's a purpose of one-to-one meeting to see what we can, what we have, what you have, and what we can do for you. And sometimes individuals want to make more than one wills. Yes, you can do that. You can make as many wills as you want. It's up to you. There's no such restriction that you should have only one will or you should have only two wills. So it depends on the nature of your assets and the volume of your assets. And we, of course, that will be one of the part of the discussion, that what kind of wills you should have. So this is, and remember, the will is always applicable after the death. Even if someone will open your will, read it, and but you are alive, there is no implementation of that will, because the activation time starts after the death. And what if someone has some uh, challenges with his or her mental health, or the doctors declare them incapacitated for the purpose of making any legal documents? So in order to cover that specific part, we always recommend you to make a power of attorney. And that power of attorney, sometimes we clients want to make it, sometimes not, but of course you should know the importance of that power of attorney. And that power of attorney is a document which will be active the time you will sign it, and that power of attorney will die with the deceased, and then will take over. So, and the power of attorneys are two kinds. One is the power of attorney which is about the property, and the second is about the health. So for the health purposes, you should also understand that the health power of the purpose of health power of attorney, if someone has been declared incapacitated, or someone is out of his subconscious, and unable to give instructions to the doctor that what the doctor should do relating to someone's health, and at that time that power of attorney always helpful, because the doctors want to ask, okay, who want to make a decision of the someone who's in the deathbed in the hospital. So if it is a spouse, then yes, they can take instructions. But if spouse is not available and someone want to make a decision about the health, at that time you need that power of attorney. So this was a brief introduction about the importance of the wills and power of attorney. I know many of you may have many questions in your mind while thinking about this process. That's why we are here, and that's why you need a qualified professional lawyer who can help you to do that. So today that session was quite precise. I just kept it a little bit, I would say, in terms of time. I'm not keeping it for very long. And but for the next session, if you guys have any question, or if you have any legal topic in your mind, you can always send me a message, or you can always get back to me, and I will be happy to include that topic in my next upcoming session. So thank you very much for joining Legal Lounge with Adil Farooq. All of you are my guests here, and I will take your leave now. And hopefully, I will see you next Tuesday, same time, 1 o'clock, with another other topic. Thank you. Bye bye. मैंने इसको पॉज किया है, मुझे इसको वो नहीं करना आया, मैंने इसको वो नहीं किया, खत्म इधर से मैंने कर दिया, ऐड कर दिया।